had to get on record. Hello.
Hello?
Hi.
Hello?
Hello, hi. This is Sean Henry, a member of the Landlord and Tenant Board, and with me is
Christina De Leon Call. Good morning, Ms. Yakni.
Yes.
and we're here for
good
99 East Avenue, Hamilton, Unit 2. A variety of applications are in view with respect to this procedural hearing, and they are SOT 77620-16, SOT 80393-17, and SOL 84218-17. If the parties would identify themselves, please.
Marie Ball.
Okay, so Marie Ball, Ms. Ball, I heard you. Thank you. A tenant. Is Peter Bosch in attendance?
Yes, sir, I am.
Oh, can you just state your name then, sir?
Paul Peter Bosch.
Thank you so much. Bear with us a second as we have to take some notes.
Wadi Yakni, landlord representative.
Thank you. 1 second, please. Thank you, Ms. Yakni. Bear with me. All right. And are the landlords here at all?
No, sir, he's not present.
Okay. And you continue to represent both landlords, Ms. Yakni?
That's correct.
John Serino and Agostino Serino. Thank you so much. All right. The time now is, what is that?
5 after 2.
Thank you so much. Bear with me a second. All right. Now, we had called this procedural hearing because I think you, Ms. Yakni, submitted a request to reschedule the hearing, in advance of the hearing, obviously. In reviewing the request now, I see that it is on consent. Is that correct?
That is correct, sir.
Okay. And what's the status of your
Pardon? Sir, it is what?
on consent, Ms. Ball? I don't know whether or not it is, but in one of her correspondence...
I just couldn't hear you.
Oh,
okay, sorry about that.
Oh, my apologies.
Initially, the first request was without consent, but after that was sent in, we did receive consent, and I did submit a second request to reschedule with consent.
Thank you, which we received on April the 5th. So we actually staged this procedural hearing when their consent had not been given, so that we could explore the reasonableness of supporting the request. All right? So that's what...
Excuse me, Mr. Henry.
Yes?
The original request was filed on March 29th of 2018.
Right?
The one without consent?
Yes.
Actually, March 27th.
Okay. We gave written consent on March 27th.
Oh, my apologies. That must have been an oversight in our process. I apologize for that.
Okay.
In any event, there are still
That puzzled me, that's all.
I apologize. Well, thank you for the clarification. In any event, this procedural hearing is still of some importance so we can organize the circumstances of the continuation of these matters. Now, these matters have been joined going forward. Of course, Member De Leon Culp has one application, the landlord application. I have two, and the tenant application. And we're both somewhat midstream with respect to them. And it was concluded that for the sake of judicial efficiency and the economy of the parties' time, that we would hear these matters going forward as a panel.
Okay.
All right?
That's correct.
Yeah, we'll see how that unfolds, okay? Now, just procedurally, as I recall with respect to the two tenant applications, I was partway through the T6. I think the tenants had largely concluded the presentation of their evidence, and we broke for the day as before the hearing of the landlord response, because as I recall, Ms. Ball was experiencing some medical distress. So we still have a bit of a way to go through these matters. And Member De Leon Culp, how far are you through your matter?
I believe from my notes, we heard from Mr. John Serino, and he was cross-examined by the tenants. So that evidence has been completed. We heard from Agostino Serino as well, and he was cross-examined. We received evidence from Paul Bosch, right? And let me just see. It's Susan George. Sorry, did we receive evidence from Susan George and
Testimony.
testimony from Susan Jones.
So you were partway through your matter then, ma'am. It sounds about halfway through or so, right?
Yes.
Would that be fair? Okay.
We're halfway through.
All right.
Chairman Henry, if I may just add,
Miss, yes,
the
Miss
notes
Lackman?
I have on file, and
Yes.
I do apologize for interrupting.
No.
But we did also rest our case. We had made submission, and at the time of the adjournment, Mr. Bosch had requested additional time to present the additional video recording, and we had requested that be given the opportunity to respond to that. We did not need to respond, so there was no reply evidence, and so our case was rest.
Which application are you referring to, Ms. Yakney? Your own?
That's correct.
Okay.
Our, the landlord application.
Okay, the one before member to the on-call. Okay.
Mr. Henry, we have some procedural fairness issues that we'd like to raise. I've been advised to raise those at the first opportunity.
Well, I don't know whether this forum is appropriate for us to consider them, but why don't you identify them on a high level, and we'll assess whether or not they're appropriate for the moment. Please.
Okay. I'm not a paralegal or a legal professional, but it appears that we've been the victim of some sharp practices on the part of Mr. Serino's representative. The interim order issued on October 11, 2018 by member Leon Culp has been ignored by the representative and the landlords. There have been a number of late disclosures, including one right at the very beginning of a hearing. And due to my inexperience, I didn't know enough to object to that. There have been a number of other instances where landlord's representative has broken appointments without notice, and then
Appointments for what purpose? I'm sorry, Mr. Bosch. Appointments? Sorry, Mr. Bosch, sorry, my apologies. Appointments? What do you mean?
Yes, appointments. The interim order to which I referred earlier states that we will pay the rent to the landlord's representative at her office. Made a number of appointments, and I was there for them, and it wasn't.
Okay. So one second. Before you even feel the onus to respond, Ms. Yakney, all right, Mr. Bosch, I would suggest now that we've gotten a kind of a scope with respect to the nature of your concerns, it strikes us that this may not be the appropriate time in which to raise those. Those might be most appropriately advanced at the commencement of the return of this matter. This hearing today has been staged only to address the procedural request of the rescheduling, okay? So you may want to put a dog ear in that and raise those at the proper time. Is that reasonable?
Yeah, it is, sir, but where I was leading may tie into this as well. There's been another T2 application filed.
Right.
With a hearing date of June 1st.
That's right.
Which is the evidence presented there will be actually almost identical to the current T6 and T2 applications. We also have considerable more evidence to present for the T6, considerable new evidence. So the long and short of it is we have 4 applications that cover essentially the same events, the same thing that's gone on. And Mr. Serino has deliberately, we believe, confused the situation to the point where those issues cannot be separated. So what we're asking is that all of the applications be heard at once. We'd like to present our story chronologically from the beginning with explanations of what went on and how. We've documented our interactions with our landlord quite extensively.
Okay, so, all right. So bear with me a second, okay? Now, we're certainly aware of your new filing, okay? I'm certainly not in a position at this stage to make any ruling with respect to what you may advance, okay? Especially as it relates to what's already been addressed, okay? It's generally not seen as proper to reopen the proceeding to start afresh, okay? But again, let me to finish. Allow me to finish.
I'm sorry.
It's okay. So we won't be able to make an assessment with respect to that request, one way or the other, in terms of the flow of the hearings until the day of that hearing, where we're able to all together look at everything. So we can't make any give any direction right now. As it relates to your request that the matters be heard at the same time, okay? there may be a logic to that. We've actually brought all these matters together in a panel forum, the three existing matters, for the sake of efficiency. So it strikes me as not unlikely that the same principle might be applicable with respect to your new filing, okay? The question there becomes carving out time sufficient to kind of bring them all on. Now,
Well, Mr. Chairman,
Yes.
I've advised that it will take between 2 and 3 days of hearing time to present all of our evidence, and most likely 3.
Well,
the problem is that Mr. Serino's harassment and violation of our rights is ongoing. He can fend faster than I can do the paperwork.
okay. So what are you asking of us in this moment?
Okay, what we're asking for is an interim order. Actually, we'd like the interim order dated October 11, 2018 to be revoked. Because, as I've said, the landlord and his representative have ignored that order. And it's caused us some difficulty.
Okay, I need to interrupt you there, okay? I need to interrupt you. Before we go any further, it strikes us, at least so far, that you're to some degree exceeding the anticipated scope of today's engagement.
Okay.
Much of what you've indicated is perhaps more properly the subject matter of the full-on continued hearing. I want you to understand that.
Okay.
All right? So that's very important. In the endorsement that Member Dillon-Culp and myself sent out in support of today's hearing, we clearly identified that the scope was for the purpose of considering the request to reschedule. I would suggest it would likely be undue for you at this stage to intend to expand that scope. Okay?
All right.
All right. Now, just briefly on some of those other elements you've touched on. You've kind of volunteered an anticipated timeline, at least as to how long you might be in chief. Let's explore some of these elements, okay? All right. This is quite important, and this is also why we thought to stage this, to provide an educational framework briefly. Now, your general question, and I think one of your questions, was to be given an opportunity to start the entire process afresh so that you can create a running chronology of events. That issue notwithstanding, and it strikes me that you're going to have some procedural hurdles around supporting that request and substantive hurdles, but we'll park that for the moment and you can revive that request when we eventually come back. That notwithstanding, this is quite important. The board does not have an infinite amount of time to hear any particular matter. Okay? You've offered your estimate that it will take 3 days or whatever it is you've come to in your own math. There's some features around that are very important. There are 2 principles that the parties will have to turn their minds to as these hearings continue. And I think they're directed squarely at some of the issues you've raised. One is the principle of relevance when it comes to presenting your documents. You really want to screen your documents, both parties, to assess whether they bear upon the issues in dispute. Same with your testimony. That's very important. The second principle is probative value. Right? For example, you might have 10 pictures, all of which are relevant because they show something that matters in relation to the application. But they may not be probative because they all say the same thing. 10 of them together may not move the ball forward any more than any one of them. Does that make sense?
It does, Mr. Chairman.
Okay. I'm not asking you to, I'm not debating you on this. Just hear me out, okay? I'm trying to provide an educational framework with your permission. And I won't proceed without your permission. So you tell me whether I can go ahead.
Go ahead, sir.
Go ahead, sir.
All right. I have no clue whether what you intend to present meets those criteria. I'm not in any sense declining any interest you may have in advancing those at this stage. So don't interpret it that way, okay?
All right.
It seemed that way.
Well, and this is why I said it, because it struck me that you drew the wrong conclusion from what I'm saying. May I continue with your permission?
Yes.
Ma'am?
Yes, sir. You may.
Now, the reason I'm saying this is legion. One, we as adjudicators are only human. And the more information we get, is the greater the risk that the actual kernels, the nuggets that matter extremely, that are a linchpin for the purpose of advancing your position might get lost. That's so very important, okay? Number two, the more information that's given to us is the longer a proceeding will take. And hearings take as long as they naturally take. Nothing wrong with that. This is not my suggestion to you that you truncate the advancement of your case. What I will say is this, and this is quite important. To the extent that we are exposed to evidence that is unduly repetitious or that unnecessarily prolongs the proceedings, we have at our discretion the opportunity to consider seeking submissions for costs, board costs, in relation to our squandered time. You understand that much?
Yes, sir.
Yes, we do.
Okay, so I thought it important to give you a bit of a heads up, because I want you to, as much as you possibly can, avoid those pitfalls. Because we do exercise our cost award powers in appropriate circumstances. So you bear a very specific obligation, and this is what it is. You bear the obligation to the administration of justice to review all of your intended documents and all of your intended testimony and ask yourself the two questions that I just framed out. Now, this is not my invitation for you to shortcut the presentation of your case, but what I do not want, and Member de Leon does not want, is a document dump. You need to do some screening and filtering and rationalize the presentation of your evidence. Do you understand that?
Yes, sir.
Sir, I do not hear you. Pardon me?
Yes.
Yes, I do understand that.
All right. So, in any event, who knows how long it will take? I haven't the slightest idea. Member de Leon Culp hasn't the slightest idea. You, in fact, haven't the slightest idea. But that's not what today's procedural hearing is about. So what we intend to do is to put this over to, obviously, we're going to grant the request, okay?
Thank you.
Member, do you agree?
Of course.
All right. Now, we're going to explore. I understand that currently Member de Leon Culp is assigned to the docket where your June 1st matter is to be heard. That's what I understand so far.
Yes.
These dockets are subject to change though, okay? So bear with me a second. I'm just taking some notes. All right. So we're going to, Member de Leon Culp and I are going to contemplate the prospect of pulling out the June 1st matter to be heard whenever we hear the continuation of these matters. We're making no commitments around that, but we're going to explore that possibility. Is that understood?
Yes, sir.
Yes.
All right. Now this is quite important, all right? And this probably more impacts the two existing tenant applications plus the yet to be heard one than it does Member de Leon Culp's continuation, based upon what you've told me, okay? I think, now I don't know, I'm going to consider your requests at the time these matters are called back. But I'm going to say this again. It is not the board's general practice to simply discard evidence already given and start the matter afresh as a general principle for party convenience. So,
That's not what I'm asking, sir.
I'm sorry?
That is not what I'm asking.
What are you asking?
We're asking to be allowed to present the evidence in chronological order as I asked in the first hearing in March.
Okay, so let me step back from that, okay?
Sir, there's just no other way to present this case.
Let me finish, because I remember this engagement previously, so I want to shape a response to this. It's not for me to control how you present your evidence, but you need to understand something, okay? Typically, I am best equipped to understand the party's case on multiple issues on an issue-by-issue basis. You may have experienced these events sequentially during the course of your life. I get it. But you know what your job is? Your job is to work like the Dickens, to make an absolute stranger like myself, who is charged with making assessments on your case. Your job is to help me understand the evidence. Now, and when I indicate to you, I need to see this on an issue I understand more easily on an issue basis. You may want to take some guidance from that. Do you understand that?
I do, Mr. Chairman, but I've struggled for over a year to try and separate these issues, and it can't be done. And I've talked to lawyers about this, and they agree. It's too complicated and interrelated.
Well, I'm going to say this.
The situation has evolved considerably
I'm
from
going
the
to
first
say, I'm going to say
hearing
this.
in March of last year.
Okay, I can't prejudge anything pertaining to the yet-to-be-heard application. I don't know. I haven't considered any of it at all. So I'm not predisposed on any basis. I'm making... don't interrupt me, please. May I continue? I asked you a question. May I continue?
I didn't hear your question, sir. Yes, you may.
All right. Ma'am, may I continue?
Yes, you may.
Yes.
The only reason I'm speaking is for your education. I actually know what I'm doing, but I want to create a bridge to help you engage me in a way that will promote my understanding. Do you understand that?
Yes, sir.
I'm not married to any specific approach. I'm only saying that if we're dealing with specific issues, I best apprehend such issues, as do many of my colleagues in my observation, in taking them on an issue-by-issue basis. To the extent that I find that your approach impairs my ability to understand, you run the risk of me not getting it, and to the extent that that approach unduly delays the proceeding, you stand at risk of me contemplating seeking submissions on board costs. Do you understand that?
Yes, sir.
Sir?
Yes.
All right. So here's my goal. I'm speaking, I think Member DeLeon-Culp will agree with me in terms of her continued matter. Our goal is that these matters proceed as expeditiously and efficiently as they possibly can, short of either party sacrificing their interest before the board. But if you're having difficulty framing these things out on an issue-by-issue basis, here's my suggestion. Redouble your efforts. Because at the end of the day, here's what's going to happen. Your job is to facilitate my understanding. That's the only job you have here. My job is to let you know when I'm not understanding and frame out to me how I can better receive the information. Do you understand that?
Yes, sir.
Sir?
Yes.
Yes, I understand that, Mr. Chairman, but... All right, I do understand.
If you insist on... Look, I'm only saying this for your benefit. If you choose to ignore, I'm telling you, you do so simply to your peril if I don't understand. So do as you wish, but I am giving you fair warning that this is the framework by which I best receive information. If you don't care about that, have at it. Is that understood?
Yes, sir.
Sir?
Yes, sir.
I didn't hear from you, sir.
Yes, yes, sir.
Good. All right. So what we'll do, we're going to, first of all, we're not exactly sure when we can bring this back, okay? As you might understand, coordinating Member DeLeon-Culp's schedule and mine is not an easy task. We're otherwise committed. So you ought not expect that this matter will be brought on expeditiously. I'm not sure if either set of you are aware of your availability for the next 4 months, or your unavailability, but consistent with the process we've established before, we could simply ask you to submit to our hearing coordinator the dates for which you will not be available for the next, I would say, 5 months.
Okay.
Could you do that?
All right.
Okay.
Everyone can do that, or is that a problem?
Yes, I will do that.
We can do that.
Okay. So how long would it take you to figure all that out? I don't require you to move immediately on it. What would be a reasonable period of time for you to frame out the dates for which you are not available for the next 5 months?
A week to get all my appointments. And I would agree, a week would be sufficient to coordinate with the landlord also.
Sounds good. April 20th?
That, okay. Yes, that works.
All right, bear with me a second, okay? Dates. All right, bear with me for 1 second. For 5 months. Now, query parties. Yes, here's my suggestion to you. We're going to try to establish a date that works for everyone's mutual availability. If you confer one with the other, if you do, and identify that there's a scheduling conflict, if one of you approaches the other, identifying that the date that the board has established doesn't work for you, and you approach the other side, I only request that each side act reasonably in terms of contemplating the request of the other. Is that okay?
Yes. Yes.
Yes.
All right. Then, sir, we're going to figure out when this comes back how we're going to deal with it, okay? I have no clue at this stage. I appreciate the heads up you've given me, okay? I I don't know that my impulse will be to rehear what's already been heard, although I think what you're telling me is that that's not part of your interest. It is to engage and approach chronologically, okay? My only direction to you at this stage is undertake, first of all, this is not, you're not engaged in a unique process here. We do these types of hearings dozens of times a day. And in those hearings, we tend to explore these issues, again, issue by issue basis, because you are here for the purpose of exploring specific issues with which you are discontent. So that's the process that we generally adopt. It strikes me as unlikely that whatever it is you're going to advance in your fresh application will be so unique and uncommon in the history of the board experience that you will be compelled to adopt a different approach. I would be stunned if you were that 1 in 1 million case where your issues cannot be framed out on an issue-by-issue basis. I would be amazed by that. In fact, I would be interested in seeing that. So what you're going to do, for the sake of my understanding of your issues, to empower me to help you in whatever goals you have, and to help our process run more efficiently, my direction to you is that you're going to organize on the new matter on an issue-by-issue basis. Is that understood?
Yeah, that's as best I can.
Well, of course. All we can do is our best, sir, but I do expect that best. Otherwise, we stand at risk of confounding the process. And surely that's not your goal.
No.
Okay, then. Member DeLeon, anything else administratively?
I was just wondering if the parties have exchanged all documents that they intend to rely on.
No, there will be more.
There will be more.
For the landlord application, all document that was exchanged and was introduced as evidence during the hearing. So we don't have any additional documents to add to that hearing process.
Okay. It may be...
For the record, can we have that noted so when it comes to the hearing at the last minute, we're not handed any more documents like has happened several times?
Let's frame this out. Both sets of hearings are both applications are largely midstream. Okay. Typically what would occur, not typically, but my general experience is that once we're underway in the process, we're kind of fixed in the information that would have been exchanged, okay?
The new application.
1 second. All right. Now, as it pertains to the new application, all right, I think that's where the issue of document exchange becomes relevant. Do you understand? Because at least as it pertains to the matters that I'm midstream of, it's not...
As has been Ms. Yetta, I'm sorry, I can't remember the practice. She waits until the day of the hearing and then hands it to us as we're sitting there.
Okay.
So we don't even have time to go over what she's handing us.
I understand.
We would like anything disclosed at a decent time, not the day of the hearing.
I understand. So here's my thinking, okay? I don't know if the member agrees with me on this, okay? This creates an opportunity for us to set out in an interim order disclosure deadlines for the new application. As it pertains to the historic application, to the issues I have already addressed in the application before me, I don't intend to reopen those elements already engaged in, right? So I'm thinking that we'll just proceed with what we have on the current applications, and we'll establish deadlines with respect to the new application. Remember, do you have a different view of this? How far are you in your matter?
Okay.
You're halfway through.
Let's see. Okay. Because I hadn't heard from Marie. I heard from Paul, right? I received, as I'm hearing now from Ms. Yakni, you've rested your case as far as the landlord application is concerned, and you've provided all the evidence. You've given me all the evidence you intend to rely on. But on the part of the tenants, I haven't received everything yet. Am I correct, Mr. Bosch?
Okay, before you... Okay.
The adjournment was actually, as I recall, so that you could see and hear the videos and recordings of our landlord's behavior.
Mm-hmm.
Okay.
He previously tried to frame Ms. Ball for denying him entry to the apartment, and only abandoned that plan when he found out that there was a recording of those events.
That is correct. That is, it was pending the submission of that video, and we had already finished with our direct examination of our witness. They were crossed. We had made our submission, but we had, notwithstanding, we had requested if any new evidence be introduced, that we would have the opportunity to have a reply to those evidence.
That wasn't new evidence.
I agree.
That had been disclosed.
Okay.
That's correct.
That had been disclosed.
And we didn't have any new reply for those evidence. After you disclosed it to me, I realized it was just evidence that you had given to us prior, so I didn't respond.
Okay.
And I think that was where we left off on
Yes.
that hearing,
Yeah.
the
Now-
examination of that video.
Okay, and I don't have that video yet.
Put those. I'm sorry, ma'am.
Do I have that video? You didn't give me a USB of that video, did you?
No, ma'am. It wasn't submitted into evidence yet.
Yeah, that's right. So there will, so.
Okay,
there
so
you
remember,
go.
for your component, for the order that you've undertaken, I think what you're indicating is that you're going to establish continuing disclosure deadlines, correct?
Yes.
Okay, for the ones that I'm on, that have gone through a case management hearing process, those have already been subject to disclosure deadlines. So I'm not going to introduce new ones. You're already obligated pursuant to an interim order by Member Rossiter back in 2017 to provide disclosure by certain dates. So that's the dates you're fixed with. So as it pertains to, sorry?
Henry.
Oh, Mr. Chairman, that was for the T6, as I recall, not for the T2.
Let's take a look.
That vote, just a second. I may be mistaken on that point. However, there have been amendments to the T2 application as well. And as I said, the situation has evolved considerably.
Bear with me. We're going to have to review the contents of the board's electronic record pertaining to that. Now, I don't think we even started the T2 though, one way or the other. That's another issue as well.
No, haven't. However, the point of asking for the adjournment on the landlord's application was to show the videos, which I had expected to present during the T6 and the T2.
As well.
But again, to put those videos into context, we have to start from the beginning.
Not necessarily, because when we adjourned the last time, we were already midstream, and you had just come to the point of presenting those videos. If I
Yes, ma'am. What I meant by start from the beginning was start from the beginning of the story, presented chronologically.
But we both have extensive notes, and of course we can always revisit the recording of those previous hearings, so it won't be necessary to start from the beginning.
Okay, one second. I don't think that's what the gentleman's asking. That being said, sir, you can beat the drum on that all you want. I've indicated to you the concerns I have with respect to that approach, okay? You can ignore them or take them to heart, whatever you prefer. I'll leave it in your hands, okay?
All right.
But to the extent that I get confused, I'm speaking about my matters in particular, I'm not really sure where you are, remember the Lacopes matter. And to the extent that I get confused and that inculcates unnecessary use of board time, you will face exposure to possible costs. Do you understand that?
I do.
That's all I wanted to tell you. Alright? And again, your job is to demystify things for me. And it's been my general observation that a simple chronological exploration on multiple issues, when those issues intersect over time, guess what it does to me? Confuses me. So you don't want to do that. As I indicated, because you resurrected this issue, I'm going to tell you yet again, you're going to undertake best efforts to address these issues one at a time. There may be a larger context that you want me to apprehend. I get that. Everything has a context. But better to take me through those issues in their substance, and then you can get me to context afterwards. Is that understood?
It is.
Good. All right. Anything else, member?
No.
Okay. So parties, leave it to us. We're going to send out a new interim order. We're going to figure out what to put in it. and we're going to establish a new date, okay? And we're going to see whether or not we can bring the new application on board with that, okay?
Yes, sir. Okay.
All right, so get those dates to us within what, by the 20th? We'll get something out and we'll see here. Query, I have a question for you. I know we're long in the day on this, and I know that at least one of my matters has gone through case management hearing. If we put this over to a date where we hear this to the exclusion of other matters, which Monday, this upcoming Monday, was supposed to have been, I'm thinking that I may want to see if we can get a mediator available, such that if the parties generate a newfound interest in settlement, we can access that service.
I'm going to say no to mediation right
Absolutely
now.
not, Mr. Chair.
Because every time we've tried mediation, the landlord he's not interested.
Okay, can you bear with me a second?
Fine.
Bear with me. Of course it's your right, and I'm not soliciting mediation now necessarily, but can you bear with me for a second?
Fine.
Okay. We've been doing this work for a while, so I'm going to give you the benefit of some thoughts. Not advice, but some thoughts. Whenever, I'm not suggesting you contemplate mediation, some of these matters have gone through case management hearing in any event, but just know this. Whenever I ask people if they, about mediation, what they should never do is contemplate the position of the other side or the reliability of the other side. We're all adults, and we can make free elections. And I'll turn to Ms. Yakni after I talk to you and ask her the same question. But don't make your decision based upon your expectation of the other side's resistance. We can only speak for ourselves as adults. Is that a fair position?
Fair, sir.
Sir, you're not responding. What do you think, sir? Is that a fair position?
As stated, yes.
As a general premise, we can only speak for ourselves. So I'm going to turn to the landlord shortly, but I'm going to ask you, and remember something, the value of the mediative process, I know you've gone through the CMH, which is tantamount to mediation, is that you don't have to rely on the goodwill of the other side to support whatever terms are arrived at. You don't have to do that. You have the power of the enforceable mediated agreement to rely on in the same way that you would have the power of a board order to rely on, as long as you understand that, right? I'm just thinking, maybe I'll consider trying to get someone available for that date. Any possible interest at this early stage?
No.
Okay.
Mr. Chairman,
I would be open. I think for the landlord, we would be open. I think it might help to narrow down some of the issues.
Okay.
It might resolve some of the questions. I don't know. We would not be opposed to it.
Okay, Ms. Yakni.
I'd agree to it.
Understood, thank you. Mr. Walsh, you were interrupted. What's going on there?
Mr. Chairman, as I said, the situation has evolved. When we began this, we just wanted our apartment repaired. But now we're looking for justice. Mr. Serino's behavior has been probably unique in your experience, sir. It certainly has been unique in the experience of the lawyers at the legal clinic. We want justice.
Oh, okay, now I'm going to stop you there.
And as effective as it is, it doesn't produce justice.
One
It
second,
only
one
produces
second.
results.
I want to educate you briefly, okay? May I do so, quickly? Don't worry, our job is to give justice. But I want to tell you something, if I may. My vision of justice and that of Member de Leon Culp may be different than the vision of either party, because we have different roles and different obligations in the process. And here's the one thing I never want anyone to do coming before me. I'll tell you what it is. I don't want anyone to think that because their vision of justice is so strongly held, and because they think they have smoking guns to support their version of the world, that there is an automatic clear path to an outcome of their preference. Coming before an adjudicator does one thing, and one thing only. It relinquishes the power that parties have around shaping the outcomes of their lives into an absolute stranger. And the reality of this process, Mr. Bosch, to educate you further on Ms. Ball, is in the adversarial process, one party loses automatically, and often I observe both parties feel that they've lost. Because at the end of the day, the adjudicator's role has nothing to do with supporting either party's preferred view of the world. Do you understand that?
Mr. Chairman, I do. I simply want you to enforce the law.
Sir, believe you me, you don't have to tell me my job. You don't have to worry about that. I kind of understand my job. I was trying to educate you more particularly, only in that whenever I hear someone say, we want justice, What they really say is that we want our preferred outcome based upon our vision of the facts endorsed by you, Mr. Adjudicator. And all I'm letting you know by way of education is that that's not how this process works. This process works by considering often competing articles of evidence, running that through the framework of the law, and generating something that we hope approximates justice, but that version of justice may not accord with that of either of the parties. That's all I'm telling you. All right? Understood?
Well, Mr. Chairman, it's been our experience, at least in the case with Mr. Sereno, that mediation doesn't produce justice. And my vision of justice is pretty simple. Just to have our case heard before a fair and impartial adjudicator.
Sir, that you will get, Mr. Bosch. Don't worry about that. The outcome is something else, but you will definitely get a fair and impartial hearing. Okay, parties, so anything else housekeeping-wise before I let you all go?
Not on our side, sir.
Mr. Bosch, Ms. Ball, I'm looking for a response.
I didn't hear that last question of yours.
Anything else before I let you go?
Nothing comes to mind, Marie.
Okay.
No.
Okay, we'll see you here again, okay?
Thank you, sir.
Take good care. Bye. This hearing is adjourned.
Peter Bosch and Marie Ball.